In a couple minutes, so we'll be right back, okay?
So I do.
Go to reports. Case reports. Search by scroll. Oh, wait, never mind. Here. Where's the PCC?
Okay, good morning, everybody. We're here today in First Appearance Court. My name is Judge Kim Teresa Malika. Today, you're going to be informed of the charges, and we're going to determine if there is probable cause. Today is not your trial day. Do not talk about the facts of your case. Everything's being recorded. You have a right to remain silent. We have Mr. Romero, I believe, in the main jail, and we have Mr. Reedy here in the courtroom, who are both public defenders, so they will assist you today if you so choose. If you have a private attorney, please let me know when you step up to the podium. We're going to take a couple cases at a turn. First case we have is Rickson Emanuel. Okay, State, can you announce your appearance for the record and defense?
Good morning, Your Honor. Catherine David on behalf of the state.
Eric Linder on behalf of the state.
Good morning.
Good morning, Judge. John Weeks on behalf of Rickson Emanuel, who's at the podium.
Okay, are you Mr. Rickson Emanuel?
Yes, ma'am.
Okay, sir, you're charged with count 1, robbery, no firearm or weapon. Count 2, aggravated battery with a deadly weapon. Count 1 and 2, we need to talk about bond. Do you have any objection to probable cause?
No, Judge, no objection to probable cause. I talked to the state in reference to the bond. They're recommending count 1, $10,000, count 2, $20,000. I have no objection upon that, Judge. We'll agree to that.
We also asked for no victim contact, Your Honor.
Of course.
Okay, so
Yeah, who's this?
count 1 will do $10,000. Count 2 will do $20,000. And sir, there's no victim contact, direct or indirect. That means through third parties, social media, phone calls, in person, and the like. Do you understand?
That's not what I meant, but
No contact, sir. Do you
Don't say
understand?
anything, Mr. Emanuel. Just say, you understand that there's no victim contact. Do you understand?
I understand there is no victim cost.
Okay, thank you, sir.
$100 bond.
Thank you, Judge. Have a good time.
You too.
Excellent. Then we'll just leave it where it is and you bond out.
Okay, any other private attorneys here? All right, so next one's going to be Adrian Pina Avila.
Who's that? Okay, hang on. Wait just one second. Can you ask her to hold on?
Judge, Mr. Pina Villa is going to require a Spanish interpreter.
Okay. All right.
Did you call? Oh, great, thank you so much. Your Honor, the jail has asked for one case to be called out of turn. And it is Corey Dupree, and I really wish I had written down the page number.
Judge, we're going to have to put that case on recall. He's not down here yet.
Okay.
Okay.
All right. So why is the jail asking for it to be taken out of turn then?
That I cannot answer, Judge.
Okay. All right. Next one, Kimberly May Benedetti.
Municipal ordinance case, Judge.
I know, but is it Hollywood? It's the city of Fort Lauderdale. Okay. So we will
Is this-
wait for Mr. McLawrence, Mr. Odom. We'll just put it over here on the side. Okay, ma'am, we'll be with you in a moment,
you have a
okay?
lawyer?
Have a seat. Thank you. Next one's gonna be Heather Nicole Holmes.
Judge, I've been informed she bonded.
Thank you, Mr. Romero. Okay, next one is going to be Brittany Perche Chisholm.
I've been informed she bonded as well, Judge.
Okay.
Hang on,
Okay,
Mr.
next
Peoples, I'm
one
trying
we
to do about
have
6
is
things
Nikki
here right now.
Myers.
North Broward, Judge.
I'm gonna put the phone down, just stay with me, okay?
Okay, ma'am, you have a KBS misdemeanor for loitering or soliciting for prostitution. Does she want to resolve this case today?
Yes, ma'am.
Okay, state.
Your Honor? It's an MO.
It is an MO? Oh, it is.
Yes, ma'am, it is.
Okay, so this is a Hollywood. All right, ma'am, so this is what the court will do. If you want, the court will adjudicate you and time serve you.
Yes, ma'am.
Okay, so raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, put your hand down. Is your name Nikki, Nikki, middle initial R, last name Myers, Myers?
Yes.
My understanding, you wish to waive your right to an attorney in trial, ma'am?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
Okay, you want to plead no contest to loitering?
Yes, ma'am.
All right, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you and time serve you and impose court costs of $78. The court will give you 6 months to pay that, okay, ma'am?
Does that mean I get out today?
That means you're done with this case, except for paying the $78, okay?
Thank you.
All right, you have 30 days to appeal the sentence of the court if you so choose. If you can't afford an attorney, one will be appointed. Thank you.
Thank you.
Emelina Garmer. Good morning, ma'am. You're charged with count 1, battery on an officer firefighter. We have to set bonds. It's actually counts 1, 2, and 3. You have a probation violation, or community control. It appears to be a violation.
Is this Miss Garmer, Your Honor?
Are you Miss Garmer?
Yeah.
Okay.
I was advised that Miss Garmer needed a Spanish interpreter.
Do you understand English, ma'am? Do you need an interpreter?
A little bit.
Okay, so, ma'am, I'll tell you what, have a seat, we'll get you a Spanish interpreter, okay?
All right.
Okay.
Thank
I'm gonna
you.
do the best I can for you, but I gotta go.
Thank you for telling me that, Mr. Reedy.
I'm sorry, Judge,
Brittany
I'm trying to do 6 things at once over here.
No, I
so-
understand, you're doing a great job. Brittany Ariane Evans, just like the state.
Paul Ryan, Your Honor.
You're welcome. All right, you Brittany Ariana Evans?
Yes.
Ma'am, you're charged with 1 count of grand theft auto and possession of methamphetamine. Bond has been set at $1,000 each count. The court does find probable cause. Can you afford to pay the $2,000 bond, ma'am?
Yes.
You can? Who's gonna bond you out?
Well, that's not what she told me, Judge. What Miss Evans indicated to me was that she has a friend of hers who may be able to bond her out. She gave me his name and phone number. and I'll be calling him later to see if he can do that, but she doesn't seem to think he has a lot of money. She's been living here in Florida for all of her life. She has family here, her mother and sister. She's been living at the same location for the last 4 months.
So tell me what it is you're asking for.
I would ask the court to consider pretrial release.
State?
My concern is, Your Honor,
Just so the court knows, when we interviewed her, she informed us that she has had no address for the last 4 months.
Do you have a mailing address, ma'am? Is it the 4060 Northwest 30th Terrace?
Apartment 3.
Okay, I have apartment 4, actually.
No, is this apartment 3?
Is that in Lauderdale Lakes?
Yeah, Florida 33309.
All right. Is that where you live now, or is that where you get your mail?
I live there too.
Okay.
You live there too?
Second.
Yes, and I receive mail.
Okay. All right, we can do one of two things, ma'am. We can leave your bond at $2,000. You can see if your friend can bond you out. The public defender's office can call, or we can put you on standard pretrial release. You'd have to report right as soon as you're released if it's before 4 p.m. Or you'd have to report by tomorrow if you're released after 4, like 3:30, 4 p.m.
That's it, I'll talk to you when I get a chance.
And you'd have to call in twice a week and report once a month, or you can pay the $2,000 in bond. Can I give her that option?
Yes, if she's pending verification, yes, the court can.
It has to be pending verification?
It doesn't have to be, Judge, that's up to you.
Yes, ma'am, it would have to be pending, because what would happen is if she does not post the bond, and we are able to verify her, if we verify her prior, then she'd get out. If not, she would post the bond.
She doesn't need an address to be in pretrial release, Judge. You can order her to report to downtown when she gets released.
Okay, so the court's gonna ROR her and put her on standard pretrial release.
Thank you, Your Honor.
Thank you.
That was different than what she had said before.
I understand. Ashley, I was gonna give her the option.
Yes, Your Honor, you can.
Thank you, ma'am. We're gonna put you on standard pretrial release. You have to report to the pretrial office, they'll give you instructions, okay? Please report there by tomorrow. Otherwise, you'll have a warrant out for your arrest, okay?
Okay.
Thank you. Bye-bye. Ashley Mombranch?
Hold on, Your Honor.
Okay. Good morning, ma'am. You're charged with count 1, possession of cocaine. Bond's been set at $1,000. And counts 2 and 3, we don't need to set a bond. It's possession of cannabis, 20 grams or less, and a civil traffic infraction for a sunscreen. The court does find probable cause. Can you post a $1,000 bond, ma'am?
Yes, ma'am.
You can? Okay. Good luck to you, ma'am. Have a good day.
Judge, can we go back? I know you may not have any paperwork on this case. This defendant's name is Selena Rios. She's in North Broward. It says no paperwork, but they did bring her. It's a no bond hold on a violation of probation and an out-of-county hold. She's on this afternoon? Okay. All right, that's fine.
ma'am, so we'll see you this afternoon because I don't have your paperwork, okay?
Okay. All right, thank you,
you.
thank you, ladies.
Next one is Brianna Marie Quinones. Does anybody know where she is?
Judge,
there-
I've been informed she bonded.
Okay, is she there or no?
No, she bonded, Judge.
Okay.
so in that situation.
Carmesha
Posted on the bottom.
Destin.
I've been informed she bonded as well, Judge.
Carissa Marie Esposito.
Ms. Esposito is here, President Main Judge. She is approaching.
Okay, are you Carissa Marie Esposito, ma'am?
Yes, ma'am.
Okay, ma'am, you're charged with 1 count of false report of a bomb explosive weapon of mass destruction. The court does find probable cause. State?
Your Honor, just one moment. Your Honor, the state, based on the nature of the allegations and Ms. Esposito's criminal history, which includes theft, 2014. I also show in 2001, an individual sought and obtained a permanent injunction order of protection against Ms. Esposito. And based on my concern for the safety and well-being of any and all of the employees at frankly any Bass Pro Shops in the South Florida area, I'm going to be requesting a $50,000 bond, no victim contact, no return to any Bass Pro Shops in Broward, pretrial release with a GPS monitor level 1, and no possession of any firearms, weapons, ammunition, or explosive devices until further order of the court.
Okay, defense?
Judge, I understand the nature of the allegations, it's concerning, but also in reading the probable cause affidavit, I believe she was remorseful. She cooperated with the police by giving a post-Miranda statement and saying that, Judge, she's been residing in our community for the past 20 years. She's 40 years old. She's self-employed. She's a nanny, and she cleans houses for a living. That's how she supports her daughter. She is a single mother. She averages about $300 per week. Besides that, she is going to college at FAU. She's trying to better herself for her daughter to try and obtain a better job. Her and her daughter have strong ties to community. Her daughter attends a local high school here in Broward. They've attended the same church now, St. Stephen's, for the past 7 years. She lives in Coral Springs. Right now, she has a friend that she's going to be trying to contact who's a teacher to help her post her monetary bond. From what the state has suggested, Judge, $50,000 bond is going to be tantamount to no bond on her behalf. Her friend's not going to be able to come up with that much money. What we'd be asking you to do, considering I believe Mr. Lender said the last contact that she had with the system was back in 2014 for a misdemeanor petty theft, we'd be asking you to consider, Judge, setting a $1,500 bond and placing Ms. Esposito on standard pretrial so that she may be supervised by BSO, Judge.
Okay. The court is concerned for the safety of the community. She threatened to murder the employees using a gun as a protest to their business of selling firearms to the public. Therefore, the court is going to set a $50,000 bond. The court is going to do GPS level 2. She's not to return to any Bass Pro Shop in the state of Florida, and she's not to possess any firearms, ammunition, weapons, and explosive devices at all. She's to have no victim contact, direct or indirect. Is there a victim, a specific victim?
Your Honor, I would ask that it be include, at this point in time, any employees of the Bass Pro Shop located on Gulfstream Way in Dania Beach.
Okay, did you hear that, ma'am? No contact, direct or indirect, with any employees of Bass Pro
Yes.
Shop. That includes social media. That includes through third parties, texting, blogging, calling on the phone, and the like. Do you understand, ma'am?
Yes, ma'am.
All right. Thank you.
Your Honor?
Yes.
And did the court order no
Hold on,
guns, ammunition?
one moment, bring her back.
I apologize if I missed
That's
it.
okay.
Did the court order no guns, firearm, ammunition, weapons?
No firearms, ammunition, or weapons, and explosive devices. It's my understanding pretrial goes to her house and checks and makes sure, or no? GPS level 2? All right, ma'am, if you do possess any firearms or ammunition, you're to surrender them to your local police department immediately upon your release. Thank you. Anna Velasco, sorry.
North Broward, she's gonna be a medical reset, Your Honor.
Thank you.
Good morning, Judge.
Good morning, Mr. McLawrence, how are you?
Well, I have two cases before you. Did you want me to come to the courtroom, or can I do one of them from here?
Whatever you'd like to do. I have a Terrence Jared Walker.
He's here in the main jail, Your Honor.
Okay, and then what's the other one's name?
It's Kimberly Benedetti. She should have been the second person on the docket. She's over in North Broward.
Did we do her?
I think you placed her on recall, Judge. I just spoke with her.
Okay, I have her. All right, so why don't you come to the courtroom for Benedetti since you're right next door,
Okay.
okay? So
Yes,
she can
Judge.
see you. All right, are you Mr. Terrence Jared Walker?
Yes, Judge.
Okay, sir, you're charged with the municipal city ordinance, a trespass after warning at the Family Dollar Store in Fort Lauderdale. Wish to resolve the case today?
Yes, Judge.
Okay, Mr. McLawrence?
Yes, Judge.
You
I
spoke-
spoke with him, Your Honor. And
Okay.
I explained to him that if he resolves this case, he can't go back to that Family Dollar. And he acknowledges that. He agrees not to return to that Family Dollar. He just wishes to resolve this case.
Okay, raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes, Judge.
Okay, is your name Terrence, Terrance, Jared, Jarrod, Walker, Walker?
Yes, Judge.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial.
Should we go after John asking the question?
Yes.
Is anyone forcing you to do this?
No, Judge.
Are you under the influence of any drugs, alcohol, or medication?
No.
Ever been treated for a mental illness?
Yes.
Okay, does your mental illness, don't tell me what it is, does that affect your ability to understand the nature and clarity of these proceedings here today and for you admitting to the charge of trespass? No? Okay, good. Understanding what I just explained to you, you pleading guilty or no contest, sir, to trespass after warning?
No contest.
Okay, the court is going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you, time serve you, impose court costs, which I have to by law of $78, and give you 6 months to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir.
All right. Okay, thank you, Judge. I'll be right up.
Okay. All right, next one's going to be Rosalia Dawn Poirier,
She is in,
medical loan.
no, Judge, she's here.
Okay.
She's in North Broward.
Okay, are you Miss Poirier?
Yes, ma'am.
Is that how you say your last name?
Poirier.
Poirier, okay. All right, ma'am, you're charged with burglary with assault or battery. We have to set a bond. And you're also being charged with assault, which we don't have to worry about a bond. The court does find probable cause. State?
Your Honor, on count one, which is a punishable by life offense, the state is going to be seeking a no bond hold upon a finding of proof evident or presumption great pursuant to ESASA v. State. Your Honor, noting that the allegations would certainly satisfy the elements of burglary with assault. Ms. Poirier was found in the residence when police got there. She actually barricaded herself
sorry.
in. She actually barricaded herself in the home to prevent law enforcement from taking her into custody. Her own mother, whose residence it is, apparently did not allow her permission to enter the home. She forcibly entered by pushing in a air conditioning through a window, which I believe, one moment, Your Honor.
I live there as well.
Don't say anything about the facts of the case, Miss Poirier.
Okay.
Where the officer even saw on the floor, pushed in the air conditioner that was pushed in from the window. Noting that her mother signed the affidavit for the prosecution of burglary, noting that she told her to leave the home earlier that morning, said she does not live there and is not welcome in the home. And one moment, Your Honor. No, nothing further.
Mr. Linder, did you mention to me about an out-of-state hold on Miss
Yes.
Poirier?
Your Honor, it's BSO is they're in contact with, or they're confirming through the state of Virginia. I don't know if it's in, I know in the first set of paperwork that was provided, Your Honor, when there was a medical loan, it mentions, I see, a facsimile from an Henrico County Sheriff's Office out of Virginia, which indicates their intent that they will extradite and that they have papers in hand. There's a warrant for her arrest for failure to appear in a felony drug case, Judge.
We don't, we don't know what the bond is, if any, on that charge out of Virginia, do we, or?
It's no bond. There's paperwork here, and I'll show you, Mr. Reedy. There's actually a copy of the warrant.
I don't think I have that.
Says defendant removed GPS and left group home activity she was attending.
Okay, I have seen that now, Judge. Ordinarily, when there's an out-of-state no bond hold or any other type of no bond hold, I defer argument on whether the court should find proof evident presumption great. But in this particular case, based on my conversations with Ms. Poirier, I feel compelled to point out to the court that I think there are going to be two very different sides to this story. Ms. Poirier, as I understand it, was living at this residence and apparently had a disagreement or a confrontation with her brother's girlfriend. Seems like kind of a domestic, not that it should be in domestic violence court, but it sounds like a very domestic incident. I have a feeling that probably down the road it's going to work itself out to something that's not even close to a situation where Ms. Poirier is facing life in prison. I would ask the court to set a bond for her, especially in light of the fact that the state of Virginia has not yet placed a no bond hold on her. And I understand that the court could set a bond that you felt was reasonable, but I don't think that this is the kind of case where a no bond hold is appropriate. As the court is aware, proof evident presumption great is the highest standard that we have in our criminal justice system. And based on what I see here, the fact that this is very incomplete. And from what Ms. Poirier has told me, a conversation with her mother might clear up an awful lot of what's going on in this particular case. I'd like the court to give her an opportunity, or give the state an opportunity, to contact her mother. I have her phone number if the state wants it, to see what her feelings are this morning about Ms. Poirier being held without bond. So I'd ask you to, in the abundance of caution, to set a bond for her at this time.
As I said before, the court does find probable cause. The court does further find the proof of guilt to be evident in the presumption great. Therefore, ma'am, you're going to be held no bond until further order of the court on count 1. Count 2, we're not going to set a bond on. This is without prejudice for you, ma'am, to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. You're to have no contact, direct or indirect, with your mother, brother's girlfriend. Anybody else, State?
I think that covers it, Judge.
Judge, I would ask the state, I know it's certainly not Mr. Lender's responsibility, but I would ask the state to reach out to her mother at the earliest possible convenience to determine whether or not her mother really wants to proceed with this prosecution.
And, Your Honor, I'll be frank.
Okay, let me just finish because I'm not done, folks.
Sure.
Okay, ma'am, when I say no contact, direct or indirect, that means no calling from the jail. If you do further get out of jail, or you have, I shouldn't say that because you're being held no bond. So you're not to contact any third parties, to contact your mother, your brother, or your brother's girlfriend. Do you understand that?
Yes.
All right, go ahead, Mr. Linder.
And Your Honor, and I think the court's aware, there's many situations where I will reach out to alleged victims to see their position. In this case, I'm really not inclined to, based on the allegation.
Okay, well, the public defender can reach out to the state attorney on this case. Thank you, ma'am. Good luck to you. Next one is Shannon Jenley Worthington. Shannon Worthington.
Mr. Worthington is here at main, Judge.
Okay, sir, you have a violation of probation. You're going to be going before your division judge on 2/28/2018 at 1:30. Actually, it was me that signed this warrant, so whoever the judge is, I think it's Judge Von Teff, will be hearing it. You're gonna be held no bond pending the 228 hearing. Good luck to you, sir.
Good luck, sir.
Jacob Couch.
Mr. Couch is here present, Judge? Judge, he declined the service of public defender. He has private counsel.
Okay, who's your private counsel, sir?
Natalie Oates.
Did you retain her on this violation of probation, sir?
No, ma'am.
Okay. All right, so. Does anybody know who Natalie Oakes is? Okay, sir, we're gonna have to can someone reach out to her?
And, Your Honor, I'm sorry, I didn't catch I apologize.
Natalie Oakes. Or someone give me her number, I'll call her.
I'll see if I can find it, Judge.
Does she know that you were arrested?
Yes, ma'am. She told me after magistrate to contact her and let her know when my court date would be before the real
Okay,
judge.
so she's not representing you here today? Or you wish
No,
for
not
her to?
right now, this second.
Okay, if she's not representing you, then we can have the public defender represent you, but you'll have to fill out an application, or you can represent yourself. I can tell you, you have a violation of probation for a misdemeanor, and you are gonna be held no bond. You are going to court on February 27th, 2018 at 1:30.
Okay, that's fine.
Okay? All right,
Yes,
sir.
ma'am.
February 27th, 1:30. Good luck to you, sir.
All right.
Next one is William Russell.
North Broward, Judge.
Broward Judge.
Okay, Mr. Russell, you have a violation of probation.
Yes.
Failed to appear for your scheduled appointments. You are set February 28th, 1:30, and you're gonna be held no bond pending that hearing, sir.
Okay.
Thank you. Good luck to you. Corey Dupree,
Recall, Judge.
what'd you say, Mr. Recall?
Recall, please.
Sure. Okay, Mr. McLawrence is here. Let me get that one.
Good morning, Judge.
Good morning.
It's Kimberly Benedetti. She's on page 2 of the docket, Your Honor. She's over in North Broward.
Okay. Hello, ma'am.
Good morning.
Judge, she's here on a City of Fort Lauderdale Municipal Ordinance panhandling offense.
Okay.
And I spoke with her this morning, and she desires to resolve this matter, Judge.
Okay, did you talk to her about not returning to the area?
I did, Your Honor.
Okay. All right, the court will adjudicate and time serve.
Thank you, ma'am.
Hold on. Ma'am, raise your right hand. Do you swear and/or affirm the truth?
Yes, ma'am.
Okay. Your name is Kimberly Benedetti, Benedetti.
Yes, ma'am.
It's my understanding you wish to waive your right to a trial?
Yes, ma'am.
Anybody forcing you to do this?
No.
You can put your hand down. Are you under the influence of any drugs, alcohol, or medication?
No.
Okay, you wish to plead no contest to panhandling?
Yes, ma'am.
Okay, the court's gonna adjudicate you guilty, time serve you. You're not to return to the location where you were panhandling, ma'am. You have $78 in court costs, and I'll give you 6 months to pay that, okay?
Yes, ma'am.
You have 30 days to appeal the sentence to the court. The court is gonna accept your plea and find that it's freely and voluntarily entered. Thank you, ma'am. You're done on this case. Thank you, Mr. McLawrence.
Thank you, Judge.
Okay. Did I see the Spanish interpreter? There she is. How are you, ma'am? Okay.
If the interpreter may have the page number, please.
They will have to help you with that. Sure.
I think the first
Okay,
one,
hold on one moment. Hold on. Okay, next one is going to be Marina Emelina Garmer.
North Broward.
Okay, Ms. Interpreter, if you could raise your hand for me, please. Do you swear and/or affirm to translate from Spanish to English, English to Spanish?
Yes, Your Honor. Luis Angela Lopez, LOPEZ, certified Spanish interpreter for the courthouse.
Okay, and that's Lopez?
Yes, Your Honor. Thank you.
All right, are you Maria Emelina Garmer?
¿Es usted María Emelina Garmer?
Yeah. See?
Yes.
Okay, you're being charged with battery on a law enforcement officer, firefighter, or EMT.
Señora, la están acusando de agresión física a un agente de la policía, a un bombero o a un miembro del cuerpo médico.
It's actually 3 counts,
Son 3 acusaciones de esto.
and we need to talk about setting your bond.
Y entonces tenemos que hablar de imponerle una fianza.
You also have a probation violation,
También tiene una quebrantación de una libertad vigilada.
and you're going to be appearing in front of Barbara Duffy
Y usted va a comparecer en un futuro cercano ante la juez Barbara Duffy
on 2/26/18
el 26 de febrero de 2018
at 9
a
a.m.,
las 9 de la mañana.
and you will be held no bond before you appear before Judge Duffy.
Usted hasta que no comparezca ante esa juez Duffy, a usted la mantendrán bajo custodia y no podrá pagar fianza.
And that's on count 4 only.
Y esto es solamente para la 4ª acusación.
So state, what's your recommendation on count 1, 2, and 3?
Pregunta la señora juez al señor fiscal. Señor fiscal, ¿cuál es la recomendación en cuanto a la fianza para las acusaciones 1, 2 y 3?
State would be requesting a $1,500 bond on each count, Your Honor.
Okay, defense?
El señor
Judge,
fiscal
obviously,
habla.
I was not really able to, oh, I'm sorry, go ahead.
El señor fiscal habla. Señora juez, recomendamos que impongan una fianza de $1,500 para cada una de las 3 acusaciones.
As my Spanish leaves a lot to be desired,
Okay,
I was not able to speak with Ms. Garmer about her ties to the community.
El señor abogado defensor habla en este momento. Señora juez, debido a que mi español realmente no es muy bueno, no pude comunicarme con la señora Garmer en cuanto a cuáles son sus vínculos con la comunidad.
I do note from the probable cause affidavit, as I'm sure the court has as well,
Pero sí sé a partir del affidavit de motivo fundado que estoy seguro que la corte tiene esto frente a ella.
that this incident arose as the police
Que este incidente surgió a partir de que la policía
were attempting to arrest her son,
estaban intentando arrestar o detener a su hijo.
and she came to her son's defense.
Y ella vino a defender a su hijo.
Whether that was the right or wrong thing to do will play out over time, I'm sure.
Y ya sea que esto haya sido la manera correcta o incorrecta de dirigirse a los policías, eso lo veremos y lo argumentaremos más adelante.
Also, if I'm not mistaken,
Y también, si no estoy equivocado,
it was Miss Garmer
fue la señora Garmer
who contacted the police in the first place
quien,
because there was a warrant out for her son.
si estoy en lo correcto, fue la señora Garmer la que se comunicó con la policía porque ella sabía que había o tenía entendido que había una orden de captura para su hijo.
I'm aware that she has a no bond hold.
Tengo conocimiento de que usted no puede pagar una fianza para salir en libertad.
However, I'd ask the court to take that into consideration when setting bond on counts 1, 2, and 3.
Sin embargo, le pido a la señora juez que por favor tome en consideración este hecho cuando ella imponga la fianza para las acusaciones 1, 2 y 3.
This is I believe, a 948 arrest.
Creo que esta detención es según un número de una ley que es 948,
Where the officers placed the violation of probation on her based on the arrest that we're discussing.
donde la policía puso una orden puso la quebrantación de esa libertad vigilada basados en la detención que iban a hacer en ese momento.
If the booking report is correct,
Si el informe de fichaje está en lo correcto,
Ms. Carner has been living at the same location for the last 192 months here in Fort Lauderdale.
si ese documento está en lo correcto, la señora Garmer ha estado viviendo en el mismo lugar por más de 192 meses en Fort Lauderdale.
If her prior record is not too significant,
Si sus antecedentes anteriores
I would ask-
no son tan significantes,
I would ask the court to set a low bond for Ms. Garmer on these charges.
le pediría a la señora juez que por favor le imponga una fianza bien baja a la señora Garmer para esas acusaciones.
Okay, this is what the court's gonna do. She actually, it hasn't even been 1 year since her sentence date.
La señora juez habla en este momento. Eso es lo que voy a hacer. Aquí se ve que usted no había pasado ni siquiera 100 días de que le habían dado esa sentencia o esa condena.
It concerns the court that the officers tried to push her back and she returned again.
Me preocupa que los agentes de la policía trataron de empujarla hacia otra vez para que se regresara y usted volvió a hacerlo.
And that the officers sustained lacerations to their hands, arms, and knees.
Que los agentes de la policía sostuvieron lesiones como laceraciones en las manos, en las rodillas y en I'm so sorry, hands, I'm so sorry,
Hands, arms, and knees.
en los brazos, en las manos y en las rodillas.
Therefore, the court's gonna do $1,500 bond on each count.
Por esa razón, la Corte le impondrá una fianza de $1,500 para cada una de las acusaciones, para
For a
acusaciones
total
1, 2 y 3,
for a total of $4,500.
para un total de $4,500 de fianza,
And she's gonna be held no bond on count 4.
y la van a mantener bajo custodia y no puede pagar fianza para la cuarta acusación.
She can discuss that with Judge Duffy when she sees her on February 26th.
Y
Thank
usted
you.
podrá hablar de ese caso y de esa situación con su juez, la señora juez Duffy, cuando usted la vea a ella o cuando esté frente a ella el 26 de febrero.
Thank you.
Gracias.
Next
Judge,
case, yes.
Judge, Mr. Dupree, Corey Dupree on page 8 is ready to be called.
All right, well, we have the Spanish interpreter here, so I'm gonna call one more. Adrian
Judge.
Pina Avila.
He's here at main, Judge?
Are you Mr. Pina Avila?
¿Es usted el señor Pina Ávila?
Yes,
Yes.
Okay, sir, you have an out-of-state hold for a felony.
Señor, usted tienen una orden de captura o una orden de detención por parte de otro estado por un delito grave.
Okay, it's out of Colorado for money laundering.
Esta orden de detención es por parte del estado de Colorado por lavado de dinero.
And you're gonna be held no bond, sir.
Y entonces lo van a mantener bajo custodia y no puede pagar fianza para salir en libertad.
Good luck to you.
Buena suerte.
Corey Dupree. Thank you, Madam
Mr.
Interpreter.
Dupree is approaching, Judge.
Nobody else in the jail for a Spanish interpreter?
May the interpreter
Yes.
make an announcement?
Sure.
Buenos días, damas y caballeros. ¿Hay alguien que necesite que se le interprete su caso en español? Por favor, levante la mano.
Anybody need a Spanish interpreter in North Broward? North Broward, anybody need a Spanish interpreter?
No, Your Honor.
Thank you. Conti, does anybody need a Spanish interpreter? Thank you. Paul Ryan, does anybody need a Spanish interpreter? No response from Paul Ryan. Okay, we'll go back to the main jail. Thank you,
Thank
Madam
you, Your Honor.
Interpreter.
Have a good day.
Mr. Dupree is here.
Okay, good afternoon, Mr. Dupree, or good morning. You have a capious misdemeanor for a battery. You did not show, so you have a $250 bond. Okay, it's for a battery. I can't resolve it at first appearance, at magistrate court, okay? Thank you. Welcome back.
My guess is.
Dino Anthony Mazzola.
North Broward.
Northborough, Your Honor, medical reset.
Okay. Richard Rohan Dalatram.
Good morning, Your Honor.
Good morning. How are you, sir?
I'm doing fine.
Sir, you have one count resisting an officer without violence. Bond is set at $100. And then you have the other charges, which we don't have to set bond. Counts 2 through 5, operating without a valid DL, disobeying or avoiding a red light, failure to wear a safety belt and disobey or avoid a traffic device. The court does find probable cause. Does he wish to resolve his case today?
Mr. Dollatram indicated he could make his bond. I really
Okay,
didn't
not a
discuss
problem.
about anything about resolving it. You can make your bond, right, Mr. Dollatram?
Yes, sir, I can.
Okay,
Okay,
I think
thank
that's
you,
the way to
sir.
go then.
Thank you.
Thank you, Judge, thank you.
You're welcome. Tevin Shane Sufrank.
Mr. Sufrank is here, present, Judge at Maine.
Your Honor, good morning.
Good morning, how are you?
I'm fine.
All right, you have a capious misdemeanor, sir, for driving while license is suspended. You failed to appear for court, your bond set at $500. Does he wish to resolve the case today, or can he pay the $500?
Judge, in speaking to Mr. Sufrank, he wishes to ask the court to consider resolving his case today for time served.
Okay, did you speak to him about resolving his case and,
The possible consequences? Yes, I have, Judge.
okay, okay. Pardon?
He's receiving a ad charge or bond surrender. I'm not sure what he's out on.
Hey, what's he out on?
I'll just need a moment.
Their ad charge, bond surrender.
Yeah, I believe it's gonna be on a pending possession of counterfeit bills and DWLS, and the bond on that, $1,000.
Okay, so his $1,000 bond, bond's been surrendering him, so, this is 500. So what would you like to do?
Judge, let me talk to him.
And he has a pending felony, so I don't know, Mr. Romero?
Yes, Judge?
He has a pending felony.
Your Honor, just so the court and Mr. Sufrank is aware, this would be a second DWS within 5 years, and I see that the case that's being surrendered also has a DWS, so there's a,
Yes, hold on, Judge.
Okay. So with the ad charge, Ms. Confinement, when would we have him come back? Would it be tomorrow morning? Because we have some of them today. Okay, so he can bond out again on the 1,000 though, okay. Okay, Mr. Romero, the court will put him on standard pretrial release.
I will explain that to him.
Okay.
Judge, would you be inclined, I don't know if it's possible, on the cases which the bond's been surrendered, would you also be willing to place him on pretrial, that case as well?
They said it's not for magistrate. If the state agreed, I'd consider it.
Mr. Lender, would you have an objection to that?
yeah, no, Your Honor, I imagine the bondsman had a reason for surrendering his bond. Essentially, he'd be getting a bond reduction for some issue that his bondsman decided he wasn't a good risk, so.
All right, so this is what I can do. I can give him standard pretrial on this, and then he can go before his division judge on that.
Okay, Judge, hold on one quick thing.
That or the 500.
Judge, he'll take the pretrial release, standard pretrial for this case. It's here before
Okay.
you.
Thank you very much. Thank you, sir. Next one, Juan Carlos Martyr.
Mr. Martyr is here present, Judge.
Okay, we have driving while license is suspended. Capias. What do you want to do with this, folks? Does he want to resolve it, or can he pay the 500?
No, he wishes to resolve the case, Judge.
Okay, you explain the ramifications.
I did.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, it's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, Judge.
Okay, put your hand down. Your name is Juan Carlos Martir, M-A-R-T-I-R.
Yes, ma'am.
Ever been treated for a mental illness?
Yeah, but I was young.
Okay.
Okay now.
All right, so you understand what's going on here today with clarity?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings.
Yes, ma'am.
And that could affect your ability, sir, to remain in the United States. You understand that?
Yes, ma'am.
You understand that if you get 3 convictions within 5 years, a driving while license is suspended. The Driver's License Bureau will suspend your license for 5 years as a habitual traffic offender.
Yes, ma'am.
Okay. And how do you wish to plead to driving while license is suspended, sir?
I plead guilty.
Okay, the court's gonna accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. You were driving while your license was suspended. The court will adjudicate your time, serve you, impose court costs of $293. How much time to pay?
He's going to be requesting 6 months, Judge.
Okay, the court will allow you 6 months to pay the $293. You have 30 days to appeal the sentence of the court, sir. If you can't afford an attorney, one will be appointed. Good luck to you. You're done with this case, okay?
Thank you very much.
Julio Angel Cruzado.
Mr. Cruzado is here present, Judge.
Okay,
I
Mr.
believe this is a municipal ordinance case, Judge.
Count 1 is state.
Count 1 is state obstruction of highway. Okay, count 2 is panhandling. Does he wish to resolve both cases? Court will adjudicate time served, post court cost of $78.
Mr. Cruzado, the judge is asking if you would like to resolve both cases today. Yes.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, ma'am.
Okay, put your hand down. Julio Angel Cruzado, C-R-U-Z-A-D-O.
Yes, ma'am.
It's my understanding you wish to waive your right to a trial, sir, in the obstruction of highway case.
Yes, ma'am.
Okay, and you wish to waive your right to an attorney and a trial in the municipal ordinance case. Sir, is that correct?
Yes, ma'am.
Okay, is anyone forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
Understanding what I just explained to you, are you pleading guilty or no contest to panhandling and obstruction of highway, sir?
Yes, ma'am.
No contest?
No guilty. No contest.
You sure you want to plead no contest and admit to these 2 charges, sir, and resolve all your cases today?
Yes, ma'am.
Okay, the court's gonna accept your pleas, find that they're freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court will adjudicate you and time serve you and impose court costs of $78, give you 6 months to pay in the MO case. And then in the misdemeanor case, the court will give you, or the state case, $293 in court costs and give you 1 year to pay that. Sir, you're not to return to the area where you were panhandling. Do you understand?
Yes, ma'am.
You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir.
Okay, thank you, ma'am.
Thank you. James Pownell. Okay, Mr. Pownell, you have trespass private property, 3 counts.
Yes, ma'am.
Okay, sir, you appear to keep returning to this property, and you can't do that. You're going to keep getting arrested. Do you understand that?
Understand.
Okay, this is what the court will do. If you want to admit to the charge today, the court will impose a sentence of 5 days in the Broward County Jail and give you credit for time served. Is that what you'd like to do, sir?
I'm gonna do 5 days and
Or let me correct myself, 3 days in the Broward County Jail, credit for time served.
Okay.
You can't keep going back there, sir, okay? Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, it's my understanding you wish to waive your right to an attorney in trial?
Yes, ma'am.
Okay, put your hand down. Is your name James Pownall, Pownall?
Yes.
Are you under the influence of any alcohol, drugs, or medication?
No.
Is anyone forcing you to do this, sir?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea of discharge could result in deportation proceedings and affect your ability to remain in the United States, sir?
Yes, ma'am.
Okay, understanding what I just explained to you, are you pleading guilty or no contest to trespass private property?
No contest.
Okay, the court's gonna accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's gonna adjudicate you and impose 3 days Broward County Jail on each count to run concurrent. And in each case, the court is gonna impose the mandatory court cost of $78 on each case, and the court will give you 6 months to pay on each case. And the court will give you any credit for time that you served. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Good luck to you, sir. You're done with this case, okay? Thank you. Please don't return to that area, sir. Okay, next one's going to be Keith Anthony Young.
Mr. Young is approaching, Judge?
Okay, Mr. Young, you have 2 capious misdemeanors. Bond's been set at $2,000 account by your division judge.
Judge, in speaking with Mr. Young, he also wishes to ask the court if he would consider resolving his cases today.
Sure. State.
One moment, Your Honor.
One's a 2012 case, I believe. No.
Yeah, I'm just gonna check his driving record. The DWS is more concerning.
All right, let me have him, sir, raise your right hand. Do you swear and/or affirm to tell the truth? Okay, is your name Keith Anthony Young, Y-O-U-N-G?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you get 3 driving while licenses suspended convictions, within a 5-year period, the Driver's License Bureau is gonna revoke your license as a habitual offender for 5 years?
Yes, ma'am.
Okay, state?
Yeah, I'm pulling it up right now, Your Honor. From what I can tell, this would be a first, Your Honor, so,
Okay, you don't
would-
really have, he doesn't really
No.
have, that many
No, I know,
tickets.
it'd
I
be
don't
a
know why he doesn't go and do a payment plan or something.
well, if he wants to resolve it, it's a first on both charges, so the state's offer on both would be a withhold and court costs,
Okay,
judicial notice.
withhold and court costs. Is that what you wanna do, sir? Wanna plead no contest?
Yes, ma'am.
Okay, so you're gonna plead no contest to driving while license is suspended, no valid DL, correct?
Yes, ma'am.
Okay, the court's gonna accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and your driver's license record, and, finds probable cause for the plea. The court on each count is gonna withhold and impose court costs of $293 on each count, and the court will give you 1 year to pay that, okay?
Yes, ma'am.
All right, sir, you might wanna consider going to, Dade County and trying to work something out with Broward County for a payment plan. So you can get your driver's license back, because you're gonna keep getting arrested, and then your license is gonna get suspended for 5 years, okay?
Yes, ma'am.
Thank you. Willie Anderson Smith,
Mr. Smith is Judge, come on up, Mr. Smith.
good morning, Mr. Smith, how are you feeling today?
Okay, how about yourself?
Fine, thank you. Sir, you're charged with the second offense of a DUI with alcohol or drugs. You also being charged with an unlawful blood alcohol level of higher than .15. Bond is set on counts 1 and 2 at $1,000 each. And counts 3 and 4, we don't have to deal with instead of bond, that's disobey a stop sign and possession of an open container in a motor vehicle. State?
Your Honor, his DUI was out of the, one moment.
When
State
was
of-
his first one?
Yeah, that's what I'm saying, his prior DUI was out of the state of Alabama from 2012, it is on his Florida driving record.
So is it gonna be a second and 5?
Yes,
It's gonna be a little bit over or under,
is it? Yeah, it will be a second outside of 5.
outside of 5, okay.
It's more than 5.
All right, so your recommendation here?
Your Honor, I wouldn't, if the court's inclined to reduce the bond, I would ask that it not be reduced by more than $500 on count 2. I'm concerned it is a second DUI with a breath alcohol above a .2. But I would also ask for additional release condition of no alcohol or intoxicants.
Ad monitor?
I have no objection to that.
Okay. All right, Mr. Romero.
Judge, in speaking with Mr. Smith, we're gonna be asking you to consider releasing him on standard pretrial, and this is why. He's basically been living off and on in Florida his whole life. He's 61 years old. At this time, he's not working. He's in the process of applying for disability. He lives in Wilton Manors with his mother. His mother's been at that residence for about 25 years. His mother's 88 years old and suffers from dementia. She receives Social Security, and that's what they use to pay all the household bills and everything like that. He's his mother caretaker. Right now, he doesn't think if she called him, she even has the maybe capacity to physically go to a bondsman or even maybe call a bondsman to try and see how she can possibly bond Mr. Smith out. Judge, we'd be asking you to consider releasing Mr. Smith on standard pretrial release.
Does he have any money in his possession or debit cards or anything?
Let me ask. Judge, he believes when he got arrested, he may have had $10.
Okay, the court's concerned, Mr. Romero, I have to be honest with you, on the safety, about the safety of the community. This is his second DUI, and he did have a high breath.
And Your Honor, just to make the court aware, I'm showing, one moment. Just want to see what this is. See, where do I see what kind of? Just noting, with regards to financial ability, he was driving a 2017 Toyota.
How much money does he have in the bank?
Around $500 to $600 in the bank. But
Okay.
this is where we're presented with the problem is his mother is the only person he could possibly contact. She suffers from dementia. She's not physically or mentally, maybe she couldn't go to the bank.
Who's
That's
taking
what
care
the
of the
problem
mother
is.
now, then?
She's by herself.
Do we
That's why
need to send the police over there to check on her? I mean, I have a concern, you're telling me that he's the sole caretaker and doesn't know anybody else. I mean, I think we should do a welfare check of the mother. Does he live at 657 Cypress Lane, Wilton
Yes, ma'am.
Manors?
That's where he lives.
All right, Mr.
I'll call the Wilton Manors Police Department, Judge.
Yeah, I'd like to do a welfare check of this
I'll call
lady.
now.
Judge, from what the state said, it's been over 5 years from this last DUI. At this time, Judge, he's 61 years old. He's going to be coming to court. He's not a flight risk. I don't think I've heard the state say anything as far as any failure to appears.
Okay,
He's not
Mr.
going to
Romero,
be driving it.
ROR, each count. This is what the court's gonna do. Court's gonna do a
Yes, sir.
TAD monitor, no alcohol or intoxicants. No driving without valid permission to drive. That means if he has an emergency with his mother, he's to call 911,
Understood.
okay? Standard pretrial release. Sir, do not drink, okay?
Yes, ma'am.
Thank you. Henry LaCruz McGee.
Mr. McGee is here, present, Judge, at Maine.
Okay, he has a theft to deprive, a capias. Can we resolve this case today, Mr. Linder?
Your Honor, if I could have a moment, I'm on the phone with the Wilton Manors Police.
Okay.
The reason I'm calling, we just had a defendant.
Does he wish to resolve it today?
That's what I'm talking to him. It's a 1992 case, and he self-surrendered. He was applying for a job. They told him he had this outstanding KP, so he drove
Okay,
down
so this
here.
is what the court's gonna do. Raise your right hand, sir. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, you wish to plead no contest to theft to deprive a 1992 case?
Yes, ma'am.
Okay. You want to waive your right to a trial?
Yes.
Anybody forcing you to do this?
No, ma'am.
Under the influence of any alcohol, drugs, or medication?
No.
Okay, you're going to plead no contest? Put your hand down, sir. Court's going to withhold adjudication and impose court costs of $293. How much time do you need to pay that, sir?
6 months.
Okay, the court will give you 6 months to pay, sir. If you don't pay it, Mr. Romero will tell you the ramifications of it. They'll suspend your driver's
That's what I was
license.
trying to explain to him, some of the possibilities, Judge. and
Okay.
then-
All right, go ahead then.
You win
If he
it.
doesn't want, then,
That's why I wanted it, this is like a moral, a crime involving moral turpitude. I wanted to know if he's doing this for his job. I wanted to ask him if this is gonna affect him with his job.
okay, well then go ahead and speak to him, Mr. Romero. We'll come back in a
Thank you, Judge.
moment. If he wants, I'll ROR him, okay?
Thank you, Judge, appreciate it.
You're welcome. I'm fine. Okay, so,
Judge,
do
we
you want me to
appreciate the
ROR
moment you
you?
gave us to speak. No, actually, he wishes to go ahead and resolve it with the withhold.
Okay, withhold court cost $293, 6 months to pay. Thank you.
Thank you, Judge. I'm gonna take it.
Did you explain to him, Mr. Romero, though, if he doesn't pay it, they'll suspend his license?
I will tell him right now. Good.
Okay.
Thank you, Judge. Thank you, Judge.
Why do I have a ruler here? Okay. Okay, Jonathan Kyle Lewis.
He's in Conte, Your Honor.
Conti.
Okay, you have ad charges, sir, of capious felonies, 15, 16, and 17. We need to set bond on count 15, is that correct, State?
Your Honor,
Yes.
one moment.
Jonathan Lewis.
Yeah, it's a represent. I'm just checking to see what the bond was originally set
What's a
at.
represent? I've never heard of that, I'm
It
sorry.
means, Your Honor, he had a case with the same charges, or similar charges, the state null prost, and filed,
They filed again?
refiled,
What was his bond on the first one then?
It doesn't say here, of $17,000 worth of bond on the other counts, including 16 and 17.
Your Honor, here's the procedural history. He originally had a $1,000 bond set. He was then ROR'd was then rearrested on a new case and had his bond revoked. So he was being held no bond
Why?
because he
He
committed,
was ROR.
because he got arrested on a new offense and that
Okay,
violated his
okay,
license.
a new charge, I get
So
it.
in light of all that, I'm not gonna ask for the court to place the no bond back on him. I would ask the court to place the original $1,000 bond that was set at his original first appearance.
It looks like a court order was issued on counts 3 through 11. That charge was no infoed by the state, so there is no need for Mr. Lewis to post a bond on that. Counts 1, 2, 11, 12, 13, 16, and 17, his bond is a total of 17,000. A $1,000 bond, Judge, I think is not unreasonable, so. You all right, Mr. Lewis?
Yes, sir. I was trying to figure out.
Well, we can't plead you out today. You're gonna have to go in front of your judge. You got a court date coming up on the 27th of February. Today's the 22nd, okay? So next week you'll be in front of your judge.
I have the 29th, it looks like.
You know, Judge, a lot of times the 7s and 9s look a lot to the paperwork that you get because our clerk crosses her 7s, which I do also. But it's a little clearer generally on our dockets, and it looks like the 27th to me.
Okay, that's fine,
Well, yeah, it couldn't be February 29th.
unless it's leap year.
Oh, it's unless it's leap year, that's right.
Okay, so, sir, you're gonna go before your division judge, who is Judge Barbara McCarthy, on 2/27/2018 at 8:30 a.m. I'm gonna set bond at $1,000, 15, 16, 17 each. Good luck to you, sir.
All right, good luck, Jonathan.
Here, I'll give you this. Travis Devon Robbins.
North Broward.
Mr. Robbins, how are you today?
All right.
All right, sir, you have a violation of parole. You're gonna be held no bond pending the parole board contacting you. Good luck to you, sir, okay? Daniel Santiago Hernandez.
He's here, President Judge, I may.
Okay, Mr. Hernandez, you have counts 1, 2, and 3, violation of probation in your felony cases. You are going before Judge Cholera on February 27, 2018 at 8:30 a.m. And pending that hearing, sir, you're going to be held no bond as well. Thank you.
Thank you, sir.
Ricardo Da Silva, and then it's Dennis Boo Rodriguez. Are you Mr. Da Silva?
President Maine.
Okay, Mr. Da Silva, you have a violation of community control. It appears you're going before Judge Fine on March 2nd, 2018 at 8:45 a.m. And pending that hearing, sir, you're going to be held no bond as well. Thank you. Good luck to you, sir. Okay?
Thank you, ma'am.
You're welcome. Dennis Boo Rodriguez.
He's here, President Judge.
Mr. Boo Rodriguez, you have a violation of probation for a felony. You are going before your division judge, Barbara McCarthy, on February 26, 2018 at 8:30 a.m. You're going to be held no bond pending your hearing on February 26. Good luck to you, sir. Next one's going to be Doral Williams, and then after that, we're going to have Angel Cavalli.
Mr. Williams, come on up, please.
Okay, Mr. Williams, you are charged with 1 count of fraud, uttering a false instrument, and count 2, grand theft between $300 and $5,000. Bond's been set at $1,000 each count for a total bond of $2,000. The court does find probable cause. Anybody wish to be heard regarding bond?
No, Your Honor.
Defense?
Judge, yes, speaking of Mr. Williams, he's 51 years old, been here his whole entire life. He's working part-time. He works in the Port of Miami. He packs up suitcases. He just got the job. He's making about 6 months. He's been there about 6 months, making about $10 a day, $10 an hour. He lives in Miami with his brother. His brother right now is unemployed. So right now, financially, there's really nobody that has the funds to go ahead and post his monetary bond. Judge, we'd be asking you to consider releasing Mr. Williams on standard pretrial release.
Your Honor, he does have a pending case out of Miami-Dade. It's an improper exhibition of a weapon.
Okay, this is what the court's gonna do. The court's gonna ROR him on each count. No return, sir, to or contact, direct or indirect, with the check cashing store on University Drive in Miramar.
Thank you, Judge.
Hold on, I just wanna verify his address. 1266 Northwest Fifth Street.
Is that your address? Yes.
All right, sir, if your address changes, it's your responsibility to notify your attorney at the public defender's office or your private attorney and the clerk's office immediately in writing. Thank you. Good luck to you, sir. Angel Cavally. Mr. Cavally, you have a violation of probation for... Okay, sir, you have a violation of probation for a felony. You're going before your division judge, Judge Merrigan, on February 27, 2018 at 8:45 a.m. And pending that hearing, sir, you're going to be held no bond as well. Good luck to you, sir.
Thank you.
Stefan Youssef.
Good morning.
Good morning, sir. How are you?
All right, yourself?
Fine, thank you. Sir, you have a violation of probation for a felony. You're going to be held no bond as well. You're going to go before your judge, Andrew Siegel, on February 26, 2018 at 8:30 a.m. Okay, sir? Good luck to you.
Thank you.
You're welcome. Kendrick Moore. Okay, Mr. Moore, same thing with you. You have a violation of probation for a felony. You're going before your division judge, Judge Morton S. Fine, on March 2nd, 2018 at 8:45 a.m. You're going to be held no bond pending that hearing, sir. Good luck to you. Next one is Christopher Clark.
Christopher Clark was removed off the docket.
Removed. Okay, any reason why? That I need to know? Okay, that's fine. I just wanted to know. That's fine. Great. All right, Alfonso Miller.
Mr. Miller has family members here, Your Honor.
Okay. Okay, are you Mr. Alfonso Miller? Okay, are you represented, is he represented by the public defender, private attorney?
I don't know.
Can't
I
hear
can't
you.
hear you, Hector.
He applied with the public defender, Judge.
He applied?
Yes, Judge.
Okay. All right, Mr. Miller, you are charged with aggravated assault with a deadly weapon without intent to kill. The court does find probable cause. We do have to talk about setting your bond today.
Judge, I have some issues with the probable cause in this case.
All right, hold on a moment. We do have some family members here or friends that are here today. Can you all state your name?
Leslie Johnson,
Okay, and your relation to Mr. Miller?
his wife.
Okay.
Jannar Miller, I'm his son.
Coach Dwight Devon, friend.
Okay.
Judge, here am I.
Hold on, I want this other gentleman to.
Oh, I'm sorry. Go ahead. I'm sorry, Judge.
There's one
James
more.
McClam, we work together.
Okay, thank you, sir. All right, go ahead.
Judge, here are my concerns. Mr. Miller and the alleged victim in the case apparently have some type of dispute over some work that was done on Mr. Miller's car. And the allegation is that Mr. Miller pointed a handgun at him during a dispute. However, the incident is witnessed by the victim's sister. Obviously, there's some kind of ongoing history between these two individuals. We don't know. This is not an independent witness. This is someone closely connected to the alleged victim. But I think there's a real question as to whether or not a firearm was involved in this case. Mr. Miller gave a statement to the police indicating that he had a bottle in his pocket but did not have a gun. And he stated that the bottle stayed in his pocket the entire time. Miss Johnson, Mr. Miller's wife, stated that she was asleep, but she did provide a handgun to the police. It was a small .25 caliber handgun that did not match the description that the victim and the witness gave me. By the way, the description of that firearm appears nowhere in the four corners of this probable cause affidavit. The detective responds, conducts an interview with all the parties, and is given the handgun suspected to be involved by Mr. Miller, which doesn't make any sense since the handgun that was provided by Ms. Thompson was not the gun involved in the case. So my question really is, and maybe not so much for probable cause, but I think it's certainly something the court can take into consideration for bond, that there's a real dispute as to whether or not there was a gun involved in this case at all. No description is given of the firearm. The independent witness is not an independent witness, and Mr. Miller's statement is that he did not have a gun. And there's apparently a fairly long-standing dispute between the two of them. And what's interesting to me also is that this is an incident between coworkers, and we have one of Mr. Miller's coworkers coming to court on his behalf this morning. So I asked the court to take all those things into account, as well as his ties to the community, when deciding what an appropriate bond should be in this case. The family's indicated to me they can possibly come up, if the court was to set bond at $1,000, they might be able to make that. The court may also want to consider pretrial release.
Let me ask you this, how far are they as neighbors? And don't,
My understanding is the victim doesn't even live there.
it says I respond in reference to a disturbance between neighbors.
Well, my
Hold
understanding.
on, his address is 1531, it says, and it says this is 1525. So I don't know if this is the next building over, because it appears there's
Looks like they live close.
apartment numbers, maybe it's duplexes, I don't know.
I mean, it certainly would seem they live close, but Your Honor, if I may, as
Sure.
far as the weight of the evidence, I noticed the one thing that Mr. Reedy left out is there's a second witness who is an independent witness because he's a co-worker of both Mr. Miller and the alleged victim.
So these two work together, or?
I don't know if they worked together or if some work was done, but what I do know is, Mr. Reedy only mentioned one of the witnesses. There's a second witness who does not appear, based on the description, to have any reason to lie on behalf of either party. And he corroborated. Both stated they saw Mr. Miller with a handgun. They both described the incident the same, in which they stated Mr. Miller pointed the handgun at Mr. Thompson. So if you're going to mention one of the witnesses, you got to mention all the witnesses.
And we don't know what
All right,
possible
let's-
motivation that witness has either, Judge.
All right, this is my concern. Putting aside the bond for a second, what about contact? I mean, the officer did write in the report at the end of Building 9, and I don't know if Building 9 is where it says number 3, if that's an apartment number or a building number. And the defendant has number 1. Is 1 a apartment number or a building number?
One is the apartment number.
Is that Building 9?
Yeah, we stay in building 9. He doesn't stay there. His sister stays there.
What about the work situation? I mean, that's a concern. There's a gun involved in this.
I can speak a little bit as far as the work situation, Judge.
Okay, go ahead,
My
Mr. Romero.
understanding is, the alleged victim and Mr. Miller work for the same property management company. However, Mr. Miller is involved in managing a building which is called the Collins Complex. The alleged victim works at a building complex called Alden. They're in two different cities. One is in Hollywood, the other's in Fort Lauderdale. So as far as work-related contact, there's not going to be any need to have any sort of contact because they both work in different buildings.
Do they
Work for the
report, do they report to the same workplace?
From my understanding, no, Judge.
Okay, they're saying
So there
no in the
wouldn't be any-
courtroom here. Okay,
Excuse me, Judge?
they're saying no in the courtroom to my question.
My understanding is no, they wouldn't.
All right, so Mr. Linder, what do you suggest?
Your Honor, we are going based on the alleged use of a firearm and the allegations, and I can advise the court, from what I can see on the internet, the two locations are just under 400 feet apart from one another. We would be seeking a $15,000 bond, no victim contact, no possession of any firearms, weapons, or ammunition until further order of the court.
My understanding is that would be beyond the financial capabilities of the family. And based on the inconsistencies in the probable cause affidavit, I would ask the court to consider a $500 bond. That the family can make.
If I could give you a little bit also background information regarding Mr. Miller and his financial situation. Judge, in speaking with Mr. Miller, he's 47 years old, been residing in our community for the past 30 years. He is married. Him and his wife do have 4 children. They live in Fort Lauderdale, been renting and living at the same apartment now for about 18 years. Their monthly rent is approximately $700 per month. Right now, their children are grown. I believe one is in college, but they still do provide financial support. At this time, Judge, he also, as a way to supplement his income, he's a substitute teacher. Besides that, he does help out in the community. As he's right now one of the assistant coaches at the Hallandale football program. I believe an assistant coach actually came here to lend support. Judge, my understanding as far as his prior contact with the system is basically one of that does not involve any violent offenses. I believe he had a driving while license suspended about maybe 15 years
I'm
ago.
not worried
something
about a
like that.
traffic offense.
Right. So that my point is, he has very strong ties to community, no substantial prior criminal history. There's no reason that they should have any sort of contact. I believe they were talking about as far as the living situation of the alleged victim. My understanding is that the victim doesn't live there. He has family that live there, but he actually physically does not reside at that place that I believe the prosecutor was giving the address for. Mr. Miller does not want to do anything or doesn't want any sort of contact with the alleged victim. He is looking forward to his day in court to dispute the allegations, as I believe you know where we're going from what my colleague stated before. Judge, at this time, I'd ask you to consider setting a $500 bond on Mr. Miller's behalf.
And also, Your Honor, in speaking with the coach, if the court wants to hear from him, a brief proffer of what he would testify is that he and Mr. Miller have been responsible for a number of students in high school getting on into college and furthering their education and becoming productive members of society. Is that correct, Coach?
Well, let me tell you what concerns the court is that a handgun was used.
Supposedly.
And whether it was this handgun or another handgun, to me, there was a handgun used, and that's what the court has concern about and for the safety of the community.
Well, in all honesty, Judge, I don't want to interrupt you, but I think whether or not a handgun is used in this case is extremely up for debate.
Well, there definitely was a handgun according to this probable cause affidavit used. So what are we gonna do about the situation, because I am ordering no victim contact, direct or indirect, of this victim going to his family's house that lives right by, and I don't know if it's next door, if it's 50 feet, 100 feet, and, you know, something happening.
I don't know. I know Mr. Lender said it's somewhere in the vicinity of 400 feet.
From what I see here, Your Honor, just to be exact, it's approximately, the 2 locations are approximately 384 feet from one another.
Okay, I don't know if there's a different entrance or something like that. This is what the court's gonna do. The court is gonna do a $3,500 bond. Have you been in touch with the bondsman? Okay, you're gonna have to contact a bondsman. The court is gonna order no firearms, ammunition, or weapon, and surrender any, if you do possess any, immediately upon your release to your local law enforcement agency. You're to have no victim contact, direct or indirect. That means no contact, sir, through third parties, social media, calling, texting. If you see him, I'd walk the other way very quickly, okay? The court also is, all right, I won't do a GPS, sir, okay? Good luck to you.
Thank you.
Thank you, Judge.
Good luck to you. Okay, Anthony Maragh, M-A-R-A-G-H.
Mr. Morrow, come on up, please.
Thank you. Good luck to you. Okay, Mr. Maragh, you have a violation of probation for a felony. You are going before your division judge, Judge Howery, on February 27th, 2018 at 8:30 a.m. Good luck to you, sir. You're going to be held no bond pending that hearing. Christopher Grayhart, and then we have Michael Brian Ivansko.
Mr. Grayhart is in the North Broward Detention Center, Your Honor.
Thank you. Okay, this is a felony, so we can't resolve it. All right, Mr. Grayhart, you are charged with petty theft, 2nd degree, 3rd or subsequent offense. Therefore, they're charging this as a felony. Bond's been set at $750. The court does find probable cause. You are not to return, sir, to the 7-Eleven at 460 West Broward Boulevard, Fort Lauderdale, Florida. Do you understand that, sir?
Yes, ma'am.
Your Honor, based on my conversations with Mr. Grayhart, he would like the court to enter an order allowing him to attend the SAP program.
Okay, so we can do the SAP program. So you want me to leave the bond where it is? Okay, so the court will leave the bond where it is, it's $750, and sir, you're to attend the SAP program at the jail. Thank you.
All right.
Good luck, man.
Michael Brian Van Nisco.
Mr. Van Nisco is here, present, Judge, at Maine. He is approaching, Judge.
Okay, Mr. Van Nisco. You are charged with grand theft, count 1, between $300 and $5,000. Bond's been set at $1,000. And the next count is also at $1,000. It's user possess ID of another without the consent. And count 3, you have a capious misdemeanor for $250 for obstructing traffic. Can you afford the $1,250 bond?
Judge, in speaking to Mr. Van Nisco, he informed me that he's going to be contacting his mother to post his bond.
Okay, sir, you're to have no contact, direct or indirect, with the alleged victim in this case with the initials EL. That means not through third parties, in person, through the phone, social media, texting, and the like. Do you understand that, sir? Okay, good luck to you, sir. William Lindsay Grammer, and then we have Glenn Blackledge. Are you Mr. Grammer?
Yes, ma'am.
All right, sir, you have possession of cannabis, 20 grams or less. We have resisting an officer with violence. We need to talk about setting bond. And then we have not for magistrate court, count 3 through 6, state sentence felony. What are we doing, state?
Your Honor, one moment.
Martin County released him by mistake.
Well, he's state sentenced to 6 years in state prison. On one case, it involved a burglary, dwelling, grand theft auto, grand theft. The other case, 6 years after he violated probation on a dwelling with a battery, 2 counts of aggravated battery, grand theft. We had his mother was on the docket earlier, I believe. Yes, he was attempting to put officers' lives in jeopardy by running across Broward Boulevard. Your Honor, I'd be requesting a $2,500 bond on count 2.
Okay. Defense?
Judge, considering he has no bond hold, he's state sentenced. It's a third-degree felony. We'd be asking you to set a $1,000 bond. Also, we'd ask you to sign an order allowing us to photograph Mr. Grammer's injuries that he sustained as a result of the arrest.
Okay, the court's going to grant your request for a photo order. The court is going to set his bond and does find probable cause. He violently resisted the police officer's. Court's going to set his bond at $3,500 on count 2. Thank you. Glenn Blackledge.
He was removed off the docket.
Robert Lee Cyrus.
Mr. Cyrus, come on up, please.
Mr. Cyrus, you have a violation of probation for a felony. You're going to be held no bond till you go before your judge, Ernest Calra, on 2/27/2018 at 8:30 a.m. Good luck to you, sir.
Good luck, sir.
Trent Earl Hall.
He's approaching, Judge.
And then we have Kennel Marcellus. Okay, are you Trent Earl Hall?
He is, yes.
Okay, good morning, sir. You have grand theft between $300 and $5,000, bond set at $1,000. Count 2 is petty theft first degree, between $100 and $300. Bond set at $100. So that's $1,100 total. tell you at the outset, sir, the court is going to order no contact, direct or indirect, with the alleged victim with the initials RJM. Do you understand, sir?
Yes, ma'am.
That means no contact through third parties, social media, in person, texting, calling, and the like. Do you understand, sir? No Facebook, anything.
Yes, ma'am.
Okay. All right. So can you afford $1,100 bond, sir?
I don't know, but I'm gonna try.
Your Honor, the state would be requesting a $2,500 bond on the count one, Your Honor. He has no ties to the community. He's from Georgia. He has previous priors out of Georgia and New York,
What are his
and he had to be
priors?
extradited.
You can have a seat so you can look at your computer.
Thank you, Your Honor.
I gotta give the veteran, he was arrested 3 previous times in Florida for failing to appear in court.
He was arrested 3 previous times in Florida for failures to appear in court, Your Honor.
Criminal history, Your Honor, out of the state of New York, criminal possession controlled substance, 2000. Criminal possession controlled substance, 2000.
Does he have anything earlier than 2000? More recent? How you doing, Willie?
I don't see anything, Your Honor, but I would note it's taken 3 years. Your Honor, the KPS was issued in 2015. It's taken 3 years to get Mr. Hall down here.
3 years?
The KPS was issued in 2015. He was picked up in January in Georgia, and they just got down here from extradition.
Okay, go ahead, Mr. Romero.
Judge, in speaking to Mr. Hall, he resides in Georgia. He lives there with his wife. His wife works at a restaurant in the kitchen. Judge, he gave me the phone number to his wife. He doesn't even know if his wife's going to be able to post a monetary bond, $1,100, which is currently set. Mr. Hall is on disability. This is a 3-year-old case. He has no problem having no sort of contact with RJM as the court requested, Judge. He will come back to court to dispute these charges, Judge. We'd ask you at this time to consider reducing the bond from $1,000 to $500. That may be able to help his wife post a monetary bond.
Okay, the court, they had to extradite him, Mr. Romero, so respectfully, court's gonna leave the bond at 1,000 and 100. Thank you.
Yes, Judge.
Next one is Kennel Marcellus, and then we have Keith Knowles.
Mr. Marcellus is approaching, Judge. He declined to serve the public defense.
Okay, Mr. Marcellus, you're charged with aggravated assault without a deadly weapon. I'm sorry, with a deadly weapon without intent to kill. Do you have any objection to probable cause, sir?
Oh, no, ma'am.
Okay, the court does find probable cause. State.
Your Honor, the state would be requesting a $10,000 bond, no victim contact, and to surrender all firearms and weapons, and ammunition.
Okay, hold on. No victim contact. Do you have the victim's initials? The officer redacted it.
One moment, Judge.
The initials are JH, Your Honor.
RJH?
JH.
Hold on, sir. Okay, and you're requesting how much bond?
$10,000, Your Honor.
Okay, sir, they're requesting a $10,000 bond. Can you afford it?
No, I cannot afford that.
Okay,
I can't.
what can you afford, sir?
Right now, I'm not even working right now, but I know if you guys, I'm not really sure what I can afford, but I don't have much money. But
That's all.
Okay. All right.
And then with this, I don't even know how I got arrested because it just was a warrant, and I never been arrested for this. It just was a warrant put out for my arrest.
Mm-hmm. Okay, this is what the court's gonna do. The court's gonna put you on GPS level 2, sir. The court is gonna order no victim contact, like I said, direct or indirect, with the alleged victim with the initials JH. And you are not to possess any firearms, ammunition, or weapon. And the court is gonna set the bond at $5,000, sir. If you do have any firearms or ammunition, sir, you're to surrender them immediately upon your release to your local law enforcement. Do you understand?
Yes, ma'am.
Okay, thank you very much, sir. Good luck to you. Okay, the court's gonna take a recess.
Considering you broke the success warrant, I think you're good to ask for 15,000.
Sorry about that.
No, just around.
Okay, Mr. Romero, Keith Knowles.
Mr. Knowles is here present, Judge, at Maine.
Okay, Mr. Knowles, you have 5 violations of probation for a felony. You are going before your division judge, Judge Edward Merrigan, on 2/27/2018 at 8:45 a.m. And pending that hearing, sir, you're going to be held no bond. Thank you.
Good luck, sir.
Then we have Leslie Sherlock Boudoir.
Mr. Boudoir is here present, Judge, at Maine.
Okay, sir, you have count 1, burglary of an occupied dwelling unarmed, and count 2, petty theft, second degree, first offense. We're not going to set a bond on count 2, but count 1, we need to talk about setting a bond, and the court does find probable cause. State?
Your Honor, I believe pretrial has,
This court placed this defendant on pretrial supervision in case 17-2650 MM 48, a charge of cruelty to animals. Based on this court's finding of probable cause today, we're gonna act as his pretrial status be revoked at this time.
Who was that case pending before?
Judge Carpenter Toy, but it also appears you placed him on a GPS monitor.
What was the date that I placed him on pretrial? Or another judge?
I'm looking it up right now.
I believe it was January 29th. And, one moment, Judge.
Court order is dated January 29th. This court placed him on pretrial.
But also, yeah, he was released February 3rd.
Right, let me hear your argument as to, and then I'll make a decision on the 17 case.
Argument as to,
Any, what are you requesting for bond on count one?
$15,000, Your Honor.
And just so the court knows, when he came in on that 17 case, he came in on a capias.
On a what?
On a capias.
He failed to appear?
I'd have to check the capias
State,
out. but
tell
I
me
do
his
see-
failure to appear history and his priors.
Judge, one other matter while this is relevant to this. My understanding is he has a court date right now with Judge Carpenter Toy. At this time, as soon as he's done, the deputies are going to be transporting to the courtroom so he can be seen in Judge Carpenter Toy's.
Okay,
So I'd ask you not to take any action on the case that's before that judge, since he's going to go and see her right now.
and how does any of us know that it's going to be brought to Judge Carpenter Toy's attention?
okay, I'm not worried about that. Just, let's talk about his priors
One
and
moment.
failure to appear history.
Honor, while he's looking that up, I just wanted to share some of the notes with you that I see here in our system regarding the fact that they were actually compiling a warrant for this defendant, because it does appear that there are times when he is not home when he ought to be.
He also has a warrant right now out of Dade County, a $2,200 warrant for failing to appear on a no valid DL. I see he's been arrested twice previously for failure to appear in court.
Okay. Anything else you want to tell the court about Mr. Boudoir?
Well, it's obviously very concerning that he's brazen enough while wearing a GPS monitor on his ankle to enter into someone's property. Looks like, what was this? No, I don't want to see. His neighbor's property. Looks like, when did this happen? Is it in the morning? Yeah. So, if he's willing to do that, I don't know what he's not willing to do.
Judge, in speaking of Mr. Boudoir, I don't know if the state said that there's an active warrant out of Dade County. He's disputing that. He does not believe that there's an active warrant. He did go to court recently in Dade County to address the matter there, so he doesn't believe he recently missed any sort of court date in Dade County. Having said that, Judge, he's 39 years old, been here his whole life. He's self-employed. He does landscaping. Unfortunately, right now, from what he told me, he hasn't had any opportunity to work right now. There's no clients. He's living in Hollywood with his wife. I've been there for about 1 year now, Judge. I'd ask you to take that into consideration, determining a reasonable bond for Mr. Boudoir.
And Your Honor, I can advise the court, Mr. Boudreaux can dispute it from the courtroom, but in his NCIC hot file alert, which was just entered again today, based on his arrest, and when the docket was prepared, it is showing Miami-Dade County pickup only, reference to no valid DL with a $2,200 bond amount, where the warrant was issued, I believe, February 7th.
Okay, this is what the court's gonna do. The court finds probable cause. Court's gonna order a $5,000 bond on count 1. Count 2, I don't need to set a bond. Sir, there's no victim contact, direct or indirect, with the alleged victim with the initials JMT. That means no social media, no contact through third parties, no texting, no blogging, no calling, no in person. The court is gonna revoke your bond in 17-2650 MM40A. And Judge Carpenter, you can address the matter with Judge Carpenter-Toy when you appear before her today. Thank you. One moment. All right, Deandra Dwayne McKee.
Mr. McKay is here, present judge.
I'm sorry, Mr. McKay. Mr. McKay, you are charged with burglary of unoccupied dwelling, unarmed. Court does find probable cause. Court is going to order no victim contact, direct or indirect, with the alleged victim, RP. That means through no social media, no third parties, no calling, no in-person contact. You understand, sir? Okay. All right, so what are we doing with this state? I'm gonna make a copy, or just hold it on the side and give it to Michelle to make a copy, okay? Thank you. And you can give her this with it. No, I know.
No, that was a second agreement. It's
Oh, okay,
We just need one moment, Your Honor.
okay. We'll have Michelle run it up to Judge Carpenter-Toy.
We can also argue strength of evidence that he was caught on video doing this.
So what are you requesting for bond state?
$10,000, Your Honor.
No, it's someone's home.
Okay, what's his prior history and does he have anything pending?
History, but this involves someone's home.
He has no history, Your Honor, but this was someone's home and he was caught on the surveillance tapes.
Okay, defense?
Judge, in speaking with Mr. McKay, as the state did confirm this is his first exposure to the criminal justice system. He's 18 years old, been here his whole entire life.
What can he afford for bond?
Judge, we're going to be asking for a $2,000 bond. He's a junior in Miramar High School. He has a 3.6 GPA. He wants to go to college, already signed up for the SAT, scheduled to take it on a Saturday. He lives in Miramar with his mother. His mother does telemarketing for a living. So financial resources are very limited. I'd ask you to consider, that's why I said for a $2,000 bond.
Okay, $2,000 bond. No victim contact, sir, with the alleged initials RP, and you're not to return to that property. Do you understand?
Yes, ma'am.
Thank you. Good luck to you. Next one is Kevin Todd Peoples.
He is in North Broward, Judge.
Okay, and then after that, we have Mackenzie Colas. Okay, good morning, sir. Are you Kevin Todd Peoples?
Yes, ma'am.
Okay, sir, you are charged with burglary of an unoccupied structure unarmed. You need to talk about setting your bond. And then you have criminal mischief between $200 or less, and then count 3, trespass unoccupied structures on count 3 and 4. Bond is set at $25 each count. The court does find probable cause.
Your Honor, the defendant is currently being supervised by pretrial services in case 17-12076, CF10A for 1 count of felony petty theft. based on this court's finding of probable cause, we're gonna ask that his pretrial status be revoked at this time.
Okay. All right, State?
Your Honor, considering that he was already out and being supervised for a theft-related case, he's here on a burglary.
To career funeral home.
Yes. He's got a 2015 possession of cocaine. He violated probation, 22 months state prison. 2013 grand theft, violation of probation, 22 months. He had burglary structures in 09, 06, and 07. He violated probation. He was sentenced to 29 and a half months state prison as a habitual offender. And, I'm sorry, he had another burglary structure in 07 where he violated probation. Your Honor, State's going to be requesting a $10,000 bond on count 1, no return.
Okay, defense?
I would agree that there is probable cause, although it is a kind of unusual probable cause affidavit. Judge, in my conversation with Mr. Peoples, he's been living here all of his life. He does have family here, including his mother. He's not going to be able to post any kind of bond. He's got some medical issues that concern me. I'd ask the court to set a $1,000 bond, and if the court's so inclined to revoke his pretrial release, he's going to have to go in front of his division judge on that matter in any event. But I would like that case number again, if we could get it.
17-12076. 17-12076. You're welcome. Okay, the court is going to revoke his pretrial. The court has concerns. He was going into a funeral home. The court is going to set his bond on count 1 at $5,000, leave it at 25 on 2 and 3. And sir, there's no return to the Career Funeral Home. Do you understand?
Yes, ma'am.
Thank you. Luck to you. Mackenzie Colas, C-O-L-A-S. Then after that is going to be Wesley Mark Johnson.
Mr. Colas is here, present judge at Maine. He declined to serve as public defender.
Okay.
Good morning, Your Honor.
Good morning. Hold on just one moment, Mr. Colas. Okay, I'm sorry about that, sir. I apologize. Sir, you have count 1, possession of cannabis, 20 grams or less. Count 2, trafficking cocaine between 25 and 200 grams. Possession of MDMA, ecstasy, $1,000 bond. Possession of THC and possession of oxycodone, which is also known as Percocet. Those 3 are $1,000 bond each. And then we have a sunscreen and some other type of windshield violation. Those we're not going to set bond on. So count 1, the possession under 20 is $100. The trafficking cocaine between 28 and 200 grams is $15,000. So the total bonds is $18,100. The court does find probable cause. Can he pay that bond?
If he declined, PD.
Can you pay that bond, sir?
Yes, Your Honor.
Okay. All right, sir, this is what the court's going to do. The court's going to leave the bond in place. And the court,
I just want to let you know, it's being posted, Your Honor.
okay, and the court is going to do a GPS level 2. Thank you. Wesley Mark Johnson. Did you get that?
Mr. Johnson is here, present judge at Maine.
Okay, Mr. Johnson, you have a violation of probation. You're going before your division judge, Judge Dennis Bailey, on February 26, 2018. Is that Monday or Tuesday?
What was the date?
2/26.
That's Monday.
Okay, you're going this Monday at 8:30 a.m. before Judge Bailey. You have a bond of $1,000. So if you bond out at the $1,000, sir, then you have to appear in court on February 26, 2018, regardless, okay? If not, that's when you'll be going before Judge Bailey. Then we have Bryant Smith.
Mr. Smith is approaching judge. He's here at Maine.
Okay, are you Mr. Bryant Smith, sir?
Yes, ma'am.
Okay, good afternoon, sir. You have possession of cocaine, $1,000 bond. And then counts 2 and 3, there's no bonds, meaning $0. And then, or we're not gonna set a bond, it's basically ROR. And then counts 4 and 5, you have a violation of probation, which are gonna be held no bond. You're going before your division judge, Judge William Howery, on February 27, 2018. That's on Tuesday at 8:30 a.m. You're gonna be held no bond. And the court does find probable cause. Thank you, sir. Good luck to you, okay? Next one's gonna be Mark Cherry.
Mr. Cherry, come on up, please.
Okay, Mr. Cherry, you are charged with 2 counts of violation of probation. You have a hearing before your judge, Judge Martin S. Fine. You are going on March 2nd, 2018, and pending that hearing, sir, you're gonna be held no bond as well. Thank you and good luck to you, okay? Next one is Tavares Samuel Robinson.
I've been informed Mr. Robinson bonded, Judge.
Okay, bonded. Don't forget today, Mr. Romero, we have our extradition docket at 1 o'clock, okay?
So we'll start at 1:30. I remember you said on Tuesday, Thursday, we start at 1:30. We got it. Thank you, Judge.
All right, well, I'd like to start a little bit early. I don't know how many people, if you have time. If you don't, then we'll start at 1:30, okay? 1:15. There's only two people on the extradition docket today, so if you could be back at 1:15, we'd appreciate it, okay? If you need till 1:30, that's fine if you have lunch plans. Just let us know.
I never have much fun. Thank you, Judge.
Okay. Robert DeSerbo?
Mr. DeServo, bonded, Judge.
All right, then we have David Michael Fund
I've been
Chung.
informed he bonded, Judge.
Tyrone Nicholas Bliss, and then we have Ashley Roger
Mr.
Simpson.
Mr. Bliss is here present, Judge, at Maine.
Okay, Mr. Bliss, you are charged with 1 count of carrying a concealed firearm. Court does find probable cause. Bond's been set at 1,000. Can you pay that, sir?
Judge, he advised me that his girlfriend is posting his bond. I don't know if confinement status can look to see if his bond's already been posted.
Okay. Not yet.
Yes, Judge.
Okay, if it doesn't get posted, ask for a second look. We'll be more than happy to give you one, okay? Ashley Roger Simpson.
I've been informed he bonded.
Dwight Moses Forrest.
Mr. Forrest is approaching, Judge.
Mr. Forrest, you're charged with possession of MDMA, also known as ecstasy. $1,000 bond's been set. You also have count 2, possession of THC, $1,000 bond, and the third one is possession of cannabis, 20 grams or less. The court does find probable cause. Bond's been set at $2,100 total. Can you pay that, sir?
Judge, Mr. Forrest did advise me that his friend is going to be posting his bond.
Okay, thank you very much, sir. Good luck to you. Alexander Nelson Skelly.
Mr. Skelly has a friend here for his support, Judge.
Okay, hello, sir. How are you? Come on and step up. Are you Alexander Nelson Skelly?
Yes, Your Honor.
Okay, we have someone here today that's here to support you, sir. What's your name?
Ernie Madera,
And your relationship to Mr. Skelly?
friend.
Okay, you have been charged, sir, with burglary with assault or battery. Court does find probable cause. We need to talk about bond. State, priors pending.
Well, Your Honor, the state's gonna be seeking a no bond on the burglary with assault or battery. This is a filed case. I provided, there's a PC attached, I believe. I provided Mr. Reedy in the court with a copy of the supplement. It's a lot of the same allegations, Your Honor. Well, first, I'm seeking a no bond hold on the punishable by life offense.
So you're seeking proof, evidence, presumption, great?
Yes, Your Honor, relying upon the reports, statements given by both alleged victims, and I would also note, Your Honor, directing the court to the end of the supplemental report, that law enforcement with one of the alleged victims listened to the 911 tape that she made while the incident was, well, not that she made, the 911 call that she made while the incident was occurring. She listened to it, she identified Mr. Skelly's voice from the call. She personally knows Mr. Skelly, so she would have the ability to do so. and the officer documents, you can hear Mr. Skelly threatening to harm the alleged victim while the 911 call is being made, corroborating the victim's allegations, Your Honor. And I do have a concern, and why I'm seeking no bond to hold, is that both alleged victims advised law enforcement that Mr. Skelly made threats to kill the alleged victims. I'm also being advised he's getting an immigration hold as well. Here's what I gotta do, because for the GPS they need the victim's information. So what I do is, here's what you do.
Okay. Defense?
Your Honor, we would object to the court making a finding of proof evident presumption great in Mr. Skelly's case. That is the highest standard of proof that we have in the criminal justice system, higher even than proof beyond and to the exclusion of every reasonable doubt. The state is asking the court to make this very serious and very high finding and hold Mr. Skelly with the most severe type of pretrial detention, which is to hold him without bond, based only on the introduction of an affidavit. The state has called no witnesses. They've introduced no physical evidence. They say they have a tape of some phone calls. They haven't played that for the court to listen to, and have really done nothing other than introduce what are bare allegations in an affidavit written by someone who did not witness what took place. Based on that, we would ask the court to set bond for Mr. Skelly in this case.
Okay, sir, would you like to tell the court anything else?
May I ask, can I talk to Alex? Is that, I mean, I don't know what I'm doing right here. I don't know what the protocol
Okay.
is.
No, I don't think you can talk to Alex, but you can advise the court as to what kind of person Alex is, but you cannot talk about the facts of the case, don't discuss his relationship with the alleged victims in the case, or anything about the dog, or anything along those lines.
He's a perfect gentleman.
Your Honor, I'm going to object, and I would ask, really, this information is really only relevant if the court makes a determination that you are in fact going to set a bond. And really, at this point, for proof evident
Well, I
presumption.
can still set a bond even if I find proof evident presumption.
I
Great,
understand,
that's
but-
in my discretion, so.
I understand, but
I
that
just indulge the court and let me hear from
I'm
him,
just,
okay?
Your Honor, if I could just
I
finish
understand.
making my.
Sure.
Thank you. Your Honor, the determination should be made, though, before any of that personal information regarding it is made, so as not to even have the appearance of prejudice or bias, Your Honor, since that determination has to be made solely on the facts and not what his ties to the community are, or his criminal history, or, for instance.
Okay, thank you. Go ahead, sir.
I've known Alex he's lived with me for 3 years, he and his family, so I know them very well. He's a gentleman, he's outstanding character. I do know the person who's pressing charges, and she's crazy.
Your Honor, I'm going to object to that. That's not relevant.
Let's not go into that,
I'm
sir.
sorry.
Just confine yourself
I
to
apologize.
what a great gentleman he is. That
He
would
is,
be
he's a great gentleman, I know this. And a good father. He has 4 daughters that have been raised very well. So this is all a big surprise to me.
Okay, I have reviewed the probable cause affidavits are held in your case or filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption of guilt. Therefore, sir, you're going to be held without bond pending further order of the court. This is without prejudice, sir, to you go before your division judge and file a motion and request a hearing under State v. Arthur. The court is going to order no victim contact, direct or indirect. That means no contact, sir, through third parties, social media, no calling on the phone from the jail. Can you please give me the name of the initials of the alleged victim?
Of course, Judge, just one moment.
Confinement, does he have an immigration hold? Okay, he does have an immigration hold on him.
And, Your Honor, it's LB and PR.
Okay, sir, the alleged victim's initials are LB and PR. You're to have no contact with them. Thank you, sir. Good luck to you. Luis Santiano Damiani. Okay, sir. Good afternoon, sir. You have a violation of probation for a felony. You are going before your division judge, Judge Michael Usan, on February 26, 2018 at 9 a.m. That's Judge Usan. Thank you, sir.
Judge, we're done here at Maine. We'll see you this afternoon.
Thank you. Good luck. Okay, Dane Josephs.
Yes, ma'am.
Okay, Mr. Josephs, how are you feeling today, by the way?
I'm feeling good. I'm trying to go to task force and do the right thing because nobody's not giving me nothing. So I'm stranded out. My mom left me stranded in Florida and went to Georgia. So I'm here by myself. So I'm doing stupid stuff, but I don't really want to.
Mr. Josephs, remember when we talked earlier this morning, I asked you not to discuss any of the facts of your case?
Yes, sir.
All right, so, sir.
I'm still asking you to do that.
Sir, you are charged with petty theft, second degree, third subsequent offense, which is a third degree felony. Bond's been set at $750. You also have trespass, failure to leave the property upon order by owner. State?
Your Honor, Mr. Josephs has a lengthy history of, history of being in and out of mental health courts in Broward County. He just pled out, I believe it was before Judge Porth, a felony theft and resisting without violence January 31st of this year. He possession of cannabis and trespass last year in front of Judge Porth. Felony theft 2016 with threats to specified individuals. Felony theft 2015, uttering of forged bills 2015, felony theft 2015. I see at least 4 more felony thefts, and it just frankly
So
goes on
what
from
is your
there.
recommendation?
At this point in time, Your Honor, I'm just going to ask that the standard bond is left in place. I have no doubt the public defender's office will take the appropriate measures they believe regarding mental health issues.
That's correct, Judge. That's fine.
All right, $750 bond, sir. Good luck to you, okay? Hope you feel better. Thank you, sir. Jordan Santiago?
He's North Broward also, I believe, Judge.
I see, there's a note in here, FYI, this does not belong on the DV docket.
Your Honor, and I apologize. When I saw the docket yesterday,
Was this
I
the
didn't
one-
notice the not for magistrates. I saw the domestic violence battery by strangulation, and I saw that it was at North, and I had requested that it be sent to DV. My concern was if I waited till we got to the courtroom, they wouldn't have been able to transport him. And he would have had to wait
understand.
another day. But my mistake, it's actually, I think we're just here on the operating without a valid DL.
It's in
Because,
front of Judge Evans, yeah.
yeah, the 2 counts, I believe Judge Usan issued a court order of no bond hold on those 2 counts.
All right, well, this is what the court's gonna do. The court's gonna leave the Capias traffic $250 bond in place because he just does have 2 no bond holds. And the court does not wanna resolve it because I don't wanna, have a bad negative consequence for him pleading out his Capias traffic case. So, sir, I can tell you this, you are gonna go before your division judge, Judge Evans, on 2/28/2018 at 9 a.m. And you can talk to them about resolving your case then, or whether you should wait to resolve your felony case, okay? Good luck to you, sir. Frank Cadet, and then we have Benny Fulmore.
Frank Cadet is medical reset, Your Honor.
Okay? And then we have Benny Fulmore.
Paul Ryan.
Hello, are you Benny Fulmore?
Yes, ma'am. Good morning.
Good morning, sir. You are charged with robbery with a deadly weapon wearing a mask. We have to talk about bond as well as counts 2, 3, 4, and 7. 2 is aggravated battery, wearing a mask, same thing for count 3. Count 4 is firearm by a violent career criminal, and count 7 is a Capias felony. These are add charges and a change of charge. So the add charge is count 2, which is the aggravated battery, great bodily harm, wearing a mask. And then we have the change of charge for 1, 3, and 5, which is the robbery with a deadly weapon with the mask, aggravated battery, great bodily harm with the mask. And I have no count 5 here, so I don't know what that is for the change of charge.
That's,
It's a parole
oh, yeah.
violation, Your Honor, which Mr. Fulmore is currently being held no bond.
Okay. All right, so he is going before his division judge, which is Judge Paul Backman, on February 26, 2018 at 8 a.m. The court does find probable cause. What would you like to do with these counts?
Your Honor, and I provided the court and Mr. Reedy with a copy of Judge Singal's original findings at his original first appearance, a copy of the information the state filed in the original probable cause affidavit that was provided to Judge Singal. He found proof evident or presumption great, and it's written on the findings for the home invasion. Your Honor, based on the strength of the
That's
evidence.
count 1?
Yes. Based on, it's the same weight of the evidence contained in the probable cause affidavit now as it was on January 15th. The elements are still, for the different offense, robbery with a firearm with a mask, the elements are still satisfied in the probable cause affidavit. So I'd ask the court to find proof evident or presumption great on that count and hold him no bond. On the two, Your Honor, do you have a count 7, charge 7 on your findings? Yeah, I know.
Yes, capious felony.
Okay, on that one, it's an add charge of armed burglary. Again, I'd be asking for seeking.
Of a dwelling, because it says dwelling, structure, or conveyance.
Yes,
I'm
it's-
assuming it's a dwelling.
No, I believe it's, one moment, Your Honor, I believe it was a conveyance, oh, no, it's a dwelling, I'm sorry, Judge.
It is, okay.
Yes, so, or the curtilage thereof. So I'm gonna be asking for finding a proof evident presumption great, no bond hold on that count.
Okay, so on 7, you want proof evident presumption great. Count 1, proof evident presumption great, has already been found by Judge Singal.
On a different charge, but yes.
Okay.
As far as the remaining
Are
counts,
you
Your-
asking for a finding of proof evident presumption great
Yes,
on 1 and 7?
yes.
Okay,
Your Honor, on the remaining counts, I'm just, they're really, while they are, they've been upfiled, I am fine with the court setting the bonds that Judge Singal set originally on those counts, which would be 10,000 each on the 2 aggravated batteries and 1,000 on the weapon or ammunition charge.
count 4,
Yes, Judge.
how much?
He said it, Judge Singal said it at 1,000. I'm fine with the court leaving that in place.
Okay, so you're asking for no bond on 1 and 7, 2 and 3, 10,000 each, and count 4, 1,000.
Yes, Judge.
Okay. Defense?
In light of the fact that Mr. Fulmore has a no bond hold at this time for the parole violation on count 5, we would defer any argument regarding proof evident presumption great until such time as Mr. Fulmore can appear before his division judge.
Okay, the court has reviewed the probable cause affidavits, sir, filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, sir, you're going to be held without bond on counts 1 through 7 till further order of the court. This is without prejudice. For you to file a motion to set a bond with the assigned division judge and request a hearing under State v. Arthur. On counts 2, 3, and 4, sir, the court is going to set $10,000 bond on 2, $10,000 on count 3, and $1,000 on count 4. And again, sir, you are going to, before your division judge, Judge Paul Backman, on February 26th. That's this Monday at 8 a.m. Good luck to you, sir.
And for the record, Your Honor, our office does represent Ms. Fulmore, Mr. Fillmore. I'll be notifying his assistant public defender, Ms. Trawick, and to come and see him. And also, Mr. Fulmore, do not discuss your case with anyone except Ms. Trawick or other people from our office, all right?
Yes, sir.
Okay, good luck.
Do we need to do any victim contact?
That was already ordered by Judge Singal.
Okay.
It's still in effect.
Sir, come back up for a moment. Just reminding you, there's no contact at all, direct or indirect, with any of the alleged victims in this case. Do you understand, sir?
Yes, ma'am.
That means you can't have third parties. You call them from the jail. Anybody else call them. No communication through social media, texting, blogging, or anything like that. Do you understand, sir?
Yes, ma'am.
All right, good luck to you.
Maybe in the rare case back in the days, like no CD radios.
Okay, anything else from anybody? We're back at 1 o'clock for extraditions, and we'll begin court. If you could talk to Mr. Romero, Mr. Reedy, and tell him that we further changed it to immediately when we're following the extraditions, we'll begin magistrate court. No, but doesn't matter. I don't know what he's doing. All right, we'll be back.